morning. This is Melissa Raphan, and I want to welcome you to Dorsey's Labor and Employment 2020 Symposium. Oftentimes, when we hold our symposium, we're fortunate enough to have a new piece of legislation or a new case to discuss. The timing of this symposium coincides with us being handed a brand new world. With so much of the workforce working in remote settings, our panelists are calling in from a number of locations. There is a chance the sound quality will vary, but we do our best to keep it uniform. I want to remind you that today's webinar ends at 12:30 p.m. and we have 4 different sessions. After each session, we will take a break to allow us to change speakers. If you're looking for the materials and attendance sheets, they are available for download from Dorsey's webinar reminder sent yesterday from events@dorsey.com. Each session requires a separate sign-in sheet. Please don't forget to complete the attendance sheets and return them to attendance@dorsey.com. We will not have time for Q&A, but attendees should feel free to contact a speaker directly or reach out to their trusted Dorsey contact. Speaker contact information is included in the materials. Thank you, and we look forward to a terrific morning. So our first panel today is legislative and regulatory developments in a time of change. And as you can imagine, we could spend probably 24 straight hours talking, but we are going to limit ourselves to an hour. And we really have a star-studded panel. Mick is the head of our Labor and Employment Group nationwide. Molly Sigel is the Legislative Affairs Director and spends just about every minute from each January through June of the legislative session over at the Capitol. Now she has translated that into Zoom meetings, but she is really boots on the ground and knows what is going on. Drew James has been on the front line of all of our new legislation since the outset and has a really deep understanding, to the extent anyone could after a month, of what the new legislation means. So with that being said, Molly, I'd like to start with you. For employers, most of our attention has been focused at Congress and the President for the past few weeks, but the state government has been active as well. Help us understand what is the state of the state legislature.
All right. Well, good morning, everybody. Thank you, Melissa, for that introduction, and thank you for everyone that's participating today. When I was asked to comment on the state of the 2020 Minnesota State Legislature, I thought it would be easiest to divide this unusual year into 2 sections. Also, Melissa, do you want to switch to my slide? Pre-COVID-19 and post, or I should say current COVID-19. That's not the right. One more. There we go. There we go. Thanks. The legislature convened on February 11th to what we thought would be a pretty routine non-budget session. The February forecast showed a $1.3 billion surplus, and the House and Senate were beginning hearings on what was expected to be a large bonding bill. The political jostling was well underway in anticipation of November elections, and lobbyists were working on and monitoring a lot of bills that probably did not have a great likelihood of passing. Many of these are employer mandate related bills that we have seen in past years, and Melissa Raphan is going to go into these in more detail later in our presentation. The mood at the Capitol started to change at the very end of February, when we knew the COVID-19 virus was spreading and the state began holding hearings on Minnesota preparedness. Business went on as usual for the first 2 weeks of March, but it became increasingly clear that the coronavirus was rightfully dominating politics and policy at the Capitol, and it was no longer a safe place to gather or work. The Capitol has been closed in Minnesota to the public since March 16th. We can go on to the next slide. Despite the inability for the public to participate in person, the legislature has continued to work and pass legislation. They have suspended rules, which allows them to pass bills in one day and helps minimize the number of members that physically have to come to the Capitol to vote in person. As of today, they have passed 4 comprehensive COVID-19 related bills. These bills have codified many of the governor's executive orders, including a change to workers' compensation that provides a presumption to COVID-19 workers' compensation claims for healthcare workers and first responders. Other important measures include appropriations for small business loans, funding for healthcare response, and changes to Minnesota's unemployment system for employers and employees. The House and Senate continue to hold remote hearings and are beginning to hear bills that are not related to COVID-19. Members participate via Zoom, which is interesting and sometimes very painful to watch. And testimony is only allowed on a prearranged basis. Last week, the House and Senate agreed. Last week, the House and Senate agreed on a resolution that would allow the Senate to come into session every 3 days, but not require the House to do the same. On Monday, the Republican-controlled Senate passed a bill to allow minors to perform certain jobs at amusement parks, and a bill that would require drug manufacturers to disclose certain pharmaceutical price increases to the Department of Health. The Senate Republicans appear eager to get back to work, and their return to consistent floor sessions reflect that. Many of their members have recently given floor speeches highlighting the economic difficulties this pandemic has brought on small businesses and imploring Governor Walz to ease up restrictions and allow businesses to open. Conversely, the House of Representatives has not been in session for the last week and does not plan to go back in until, I think, the 28th of March, which is next week. While the Walz administration may not get everyone back to work as quickly as some would like, they have been working on a deliberate plan to provide COVID-19 guidance to employers. On April 20th, the Department of Labor and Industry posted a draft COVID-19 preparedness plan intended to mitigate the potential for transmission of the virus in workplaces. This was developed by an intra-agency group, including the Department of Labor and Industry, Department of Economic Development, and the Minnesota Department of Health, and is intended to provide guidance only. I think there is a hyperlink to this document on this slide. The Deed Commissioner, Steve Grove, has stated a few times this week that once a decision is made to allow additional employers back to work, he would not recommend that companies demonstrate proof of compliance to these guidelines prior to reopening. And I think that's an important thing to emphasize. I think they are trying to be really realistic and reasonable about getting employers back to work in Minnesota in a responsible way, but not necessarily requiring proof of compliance or additional restrictions and requirements for reporting to employers. It is expected that the governor will announce some additional businesses, but not all, to return to work after the most recent stay-at-home order expires on May 4th. The last thing I want to talk about is what impact COVID-19 will have on the end of session and beyond. The Minnesota Constitution requires adjournment on May 18th. In all reality, since they passed a biennial budget last year, there is really nothing the legislature has to accomplish before they adjourn. However, as I mentioned earlier, it appears all 4 caucuses and the governor are in favor of passing a bonding bill. The specific projects that will be included and the total bonding amounts are not yet negotiated, but given the likely need for economic stimulus, the pressure for a large bonding bill will be greater than ever. There could also very well be additional COVID-19 legislation that the House and Senate agree to pass prior to the session adjournment. Some of these issues are already under consideration and include allowing delays for certain business tax payments, additional funding for small business loans, grant programs for the development of COVID-19 testing, appropriations for improving broadband, and additional worker protections. And what about state finances? In what appears unprecedented, the Commissioner of Management and Budget has announced that the agency is preparing for an early May state budget projection. This is extremely unusual, and I don't know that there has ever been a time, at least in my history of lobbying, where we have come in the middle of a session after the February forecast and done another budget projection. In preparation for this, the agency is examining the state's revenue stream, which will be impacted by tax payment delays, reduced sales, corporate income, and property taxes. They will also analyze the guidelines for the use of the $1.2 billion in federal dollars allocated to Minnesota, as well as the new anticipated money that we expect as a result of the Senate's work yesterday. They'll also look at state spending to see if there are ways that they can actually cut back on spending and determine other financial obligations stemming from the pandemic. This new May forecast could be a clarifying moment and help determine if the legislature needs to make any budget changes prior to May 18th adjournment or get called back by the governor at some later date for a special session. I think one of the things that I would probably say is almost a sure thing is that we will be back in special session at least one time, potentially 2 or 3, just to deal with the unanticipated issues, both financially and potentially health and economic development that the pandemic is pressure is putting on Minnesota.
Thanks, Molly. This is Ryan, and I'm back after
Hey, Ryan.
technical difficulties. Good morning to everyone, and sorry for being a little bit late here. Melissa, the other critical state development has been Governor Walz's stay-at-home order, and most of us in Minnesota are familiar with that order to some extent. But are there issues that Minnesota employers still need to be aware of?
Always, Ryan, always. So Executive Order 2033 is Minnesota's stay-at-home order. And Minnesota obviously is not alone in issuing a stay-at-home order. 41 other states have also issued stay-at-home orders that have been modeled after the Homeland Security, Cybersecurity, Infrastructure Security Agency COVID-19 guidance. I referenced that not to give you another acronym to put on your probably laminated acronym list, but simply to say that the Homeland Security website is actually a good place to look for information. So the current executive order ends on midnight at May 3rd, 2020, unless it's extended. And the word on the street is that it will be extended insofar as it will indicate schools will not be back in session this school year, and bars and restaurants reopening is going to be pretty far out. But there is some indication that there will be some loosening of some restrictions. Obviously, we don't know what that will look like, but worth keeping in mind. And really, I think employers want to be shifting to the return to work plan. Now, there's an indication, there was just an article in the paper today that the U.S. Attorney General William Barr is threatening litigation against states whose stay-at-home orders are too restrictive. So I think that sort of federal state tug of war is also out there on the horizon. In terms of the Executive Order 2033, it has provided additional essential worker guidance, which changed between the initial stay-at-home order and the new stay-at-home order. And I think it really highlights one of the catchphrases of the day, which is that rules are being changed real time and there's no playbook. And I think that really, those two things are really helpful as employers navigate through this new world order. Process to gain clarity on the essential worker guidance as to who qualifies has changed. Again, just another indication, that there's no playbook. We're creating rules real time. And I think what needs to really govern is common sense and using your best judgment. And if you didn't get that advice from your mother, then you're kind of standing alone out there. And who doesn't like living in a world where your mother's advice actually has some value? In terms of operational issues, both as it relates to stay-at-home orders and return to work, if employers get inquiries from law enforcement, which obviously has been light so far on this issue regarding ongoing business operations, we advise that you simply take the same approach you would take with any state agency inquiry or federal agency inquiry, which is to be deferential, buy time, and consider carefully your response. I think communicating with your workforce, again in the New World Order, is going to require a different skill set in the sense that people are afraid. And if their fears are not allayed, they will translate into litigation, and Drew and I will reference that a little bit later. As it relates to multi-state As it relates to the multi-state stay-at-home orders, I think employers, particularly multi-state employers, are facing the same compliance issues that they have faced with increasing frequency over at least the last 4 years, as states have stepped in oftentimes where the federal government has left off. And we have seen clients taking, one of two approaches, which is one, follow state by state stay-at-home orders and, whatever the return to work orders look like, or take the kind of practical multi-state approach, which is follow the most restrictive. And if you're following the most restrictive, then you'll be complying with the rest. So as it relates to these stay-at-home orders and what will be return to work orders, I think employers are just going to have to be pretty nimble in terms of how they approach these issues and be guided by, kind of what makes sense and comply with the spirit of what they're being asked to do. Thank you, Ryan.
Thanks, Melissa. Molly, let me come back to you for a moment as we round out the state focus of our presentation here this morning. Late last week, Governor Walz announced that Minnesota was going to collaborate with some other Midwestern states on the process of reopening our economy. And I think I speak for everyone on the line here that when I say that we're all waiting with bated breath. So as Dorsey's Legislative Affairs Director, what is the date certain for Minnesota to be back in business?
I think that's a joke, Ryan, but I want to go back to what Melissa said, and I think Governor Walz has been incredibly transparent about his thought process about getting people back to work and this balance between public safety and the economy. And I know that the governor is trying to at least, I'm not sure how it's going to work from a practical perspective, but Ryan's talking about the alliance with Ohio, Michigan, Wisconsin, Illinois, Indiana, and Kentucky to try to coordinate, probably so that there aren't any states that are complete outliers as we're talking about getting back to work. But when I see things like is going on in states like Georgia, you wonder how easy it is going to be to coordinate with 6 other states in terms of trying to get back to work and make sure we all have what we need from a health perspective to get back to work safely.
Thanks, Molly. Drew, let's turn to you. Employers have been neck deep in trying to understand and apply new federal legislation over the past few weeks. And many are still working to get through the kinks. Why don't you give us a quick overview of what we've been facing and then talk about some of the issues that we're still dealing with that are tripping up employers?
Yeah, I'm happy to. I have the pleasure today of presenting on 2 statutes that we could easily fill an entire hour going into the details. And I know that because we have done that in the past. So rather than give the same presentation again, I will tell everyone on this webinar that we are going to give a very quick overview of the requirements under both the FFCRA and under the CARES Act. And it's important before we get into the weeds that you have a basic understanding of what we're dealing with. And the reality is that most employers who have an issue under either statute probably already know that you have an issue because it probably consumes most of your day, or at least in a not insignificant part of your week. And the 2 statutes that we're going to be talking about, not just during this presentation, but also over the course of today. The first is what's called the Families First Coronavirus Response Act. Sometimes that's called the FFCRA. And the second is what everyone's been calling the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act. One of the things that I remember from law school is that your first year you learn a bunch of acronyms, and then the second year they tell you don't use those acronyms if it can confuse anyone. So to the extent I can avoid the acronyms, I'm going to do that and try to avoid the alphabet too. Within the Families First Coronavirus Response Act, the first act that was passed by Congress, which was effective April 1, there are 2 types of paid leave benefits that I'm going to talk about in some detail here. The first is what's called the Emergency Paid Sick Leave Act. I'm going to try to call that Emergency Paid Sick Leave. And the second is what's called the EFMLEA, which is an expansion to the Family and Medical Leave Act. And sometimes I may call that the EFMLEA, sometimes I may call it the FMLA expansion. It means the same thing. And then the CARES Act you'll hear about over the course of today. If we go to the next slide, The FFCRA and the EFMLEA have a few things in common. The first is that they apply only to what we'll term as smaller employers, but employers with between 1 and 499 employees. If an employer has 500 or more employees, it's important to carefully monitor the status at the federal and state levels. There is some legislation that has been proposed to change things, but as it exists today, neither the EFMLEA nor the emergency paid sick leave would apply to those employers with 500 or more employees. Both statutes require the employer to provide a form of paid leave to their employees, and we'll get into what the parameters of that paid leave is in just a moment. Both statutes allow for up to 100% reimbursement of any amounts that are given for paid leave via payroll tax credits. And both forms of leave are only available if the employee cannot work or telework due to a need for leave due to a qualified reason that's caused by or related to COVID-19. If we go to the next slide, there is a lot of information on this slide, and I will tell you I'm not planning to spend more than just a couple of quick minutes here. But what this slide does is gives you a breakdown of what is required from an emergency paid sick leave standpoint. And from a very high level basis, the EPSLA, the act that creates an obligation to provide emergency paid sick leave, creates 6 different situations in which an employee would receive emergency paid sick leave in an amount up to 80 hours, which is generally 2 weeks of paid leave. And you can see those reasons listed on this slide. They're highlighted in red to make it even easier to try to digest. But the reality is, as you're receiving requests from employees for paid leave, you should be frequently coming back to this list and asking yourself whether or not the request falls within one of these 6 categories. And really, to make your life even easier, it's just 5 categories, because the last one, experiencing a substantially similar condition as specified by the Secretary of Health and Human Services, the HHS, as of this morning, has not clarified as to what that means. So there is no entitlement to leave for that reason until the Secretary makes some determination of what would fall within that category. So really, it's just the 5 reasons that are above. Now, to add some additional complexity to your lives, there are 2 different caps that would apply based on what reason for leave the employee is requesting. For the first 3 reasons on that list, that is a federal, state, or local quarantine or isolation order, being advised by a healthcare provider or doctor to self-quarantine, or if you are symptomatic and seeking medical diagnosis. For those 3 reasons, the paid leave is up to 80 hours, 100% rate of pay, capped at $511 per day. But for the final 3 reasons on the list, it is 100% regular rate of pay, capped at only $200 per day. So it is at a lower payment level. And it's important to keep those in mind, because that is the cap that an employer would receive in the form of a payroll tax credit. So you want to make sure that you're getting it right. Now, for the EFMLEA, what this does is it adds 1 new reason for FMLA leave. And I think virtually everyone on this call either has heard of FMLA leave or maybe has some practical experience fielding requests for leave. So what this does is adds 1 additional reason why an employee might take FMLA leave. And that reason is to care for a son or daughter whose school or childcare has closed, or whose childcare provider is unavailable due to COVID-19 related reasons. That's it. One of the common forms of confusion that we get in calls are people wondering whether, if someone is symptomatic, can they take EFMLEA leave? And the answer is no. It is only available to care for a son or daughter related to a school or childcare closure or unavailability. Now, this is only available to employees who have been employed for 30 calendar days. There is a bill pending that would change that, but as of yesterday, it's stalled in committees. It doesn't look like it's going to pass, but again, it's just very important to keep your finger on the pulse of legislative developments over the next several weeks. One major way that the EFMLEA is different from basic FMLA is that there is a paid leave obligation. You can receive up to 12 weeks of EFMLEA leave, and generally the first 2 weeks of leave are unpaid, and then the final 10 weeks would be payable at a 2/3 salary level for a full-time employee, capped at $200 per day. And the math is a little bit different for a part-time employee. You would go back and look at the preceding 6 months to determine their average regular rate of pay. And there are even different requirements for employees who are new to the company. So if you have one of those situations, feel free to contact counsel. Now, what I wanted to spend most of my time today talking about are potential landmines that are embedded within the FFCRA statute and the paid leave obligation. And then we'll spend a little bit of time on some litigation. But from a landmines perspective, the first is you've got to be very careful to make sure that you're not miscounting employees. As I mentioned earlier, the federal statute only applies to employers with fewer than 500 employees. But that requires you to figure out what individuals are employees, who counts. And thankfully, the Department of Labor has given us some guidance on that question, in that if you are an employee in the United States, you count. If you are an employee outside of the United States, you do not count. An employer should also count full-time and part-time employees, employees on leave, temporary employees, day laborers, but should not count independent contractors or any employees who have been furloughed or laid off. Now, one takeaway that everyone should have after this presentation is that it is more important than ever to make sure that you are categorizing who is an employee and who is an independent contractor correctly. Now, ironically, the trend here may be the opposite of what we typically see, in that employers may want workers to be employees to get over the 500 employee threshold. But the implications of getting it wrong in either direction can be costly. If an employer incorrectly counts a worker who is later found to be an independent contractor, that could jeopardize the employer's future application for a tax credit, could ultimately result in you being ineligible. On the other hand, if you incorrectly omit a worker who is found to be an employee, you risk liability for failure to provide benefits, which under the federal statute is considered a violation of the FLSA, as we'll get to in a little bit. Now, in addition, if you are an employer with a novel or complex management structure regarding who is the employer of the employees, this is an area where you may want to consider giving counsel a call, ideally us, because it's a highly fact-specific, intensive analysis that revolves the application of multiple tests. This is another one of those slides. There's a lot of information on this slide, and I'm not going to walk through the test specifically, other than to say it can be relatively complicated depending on how many different entities we're talking about. So if you have any question about who is the employer of these employees and whether you're subject to the FFCRA, give us a call, or at least really be careful about making sure that you're getting the analysis right and documenting it. Another potential landmine is that the fewer than 500 employees test is not a static test. The test is to be performed as of the time the employee requests leave. Now, if you are a very, very small employer, this may not apply to you. Similarly, if you are a very, very large employer, this may not apply to you. But for everyone in between, if you're within a spitting distance of 500 employees in either direction, you need to be really careful about keeping this in mind, because if you are an employer with more than 500 employees who ultimately engages in furloughs or layoffs, you could ultimately create a situation where you're now subject to the FFCRA and the paid leave obligations. And similarly, if you're an employer with fewer than 500 employees who hires and exceeds 500, you're now in a situation where if you provide paid leave benefits, you may not be eligible for the tax credits. So it's important to keep an eye on that as you go forward to make sure that you're not either subjecting yourself to potential liability or creating a situation where you may not receive the credit. Another potential landmine, and this is a call that I've received relatively frequently from small businesses, is, hey, just wanted to confirm I have fewer than employees, I'm exempt, right? And I think what caused this misnomer is in an early draft of the bill, that was the case, that there was an ability to simply apply for an exemption. And if you received it, you were exempt. But that's not how the final statute and the regulatory guidance has played out. There is an exemption available for employers who have fewer than 50 employees, but it is a very limited applicability. It applies only to the paid leave benefits under the EFMLEA, which, as we discussed, is only one situation. It is where an employee needs leave to care for a son or daughter due to a school or childcare closure. So there is an exemption in that situation. And then section 5102A5 of the EPSLA. And I can make it easy for you because that is the section of the EPSLA that says the exact same thing as the EFMLEA. So in practice, the only exemption available for smaller employers with fewer than 50 employees is where they need leave for an employee to care for a son or daughter due to a school or childcare closure or unavailability. That's it. There is no exemption for any other qualified reason for leave. For example, if an employee needs leave to care for a parent who is directed to self-quarantine by a doctor due to COVID-19 concerns, there is no exemption in the FFCRA. Even the smallest of employers would be obligated to provide up to 80 hours of paid leave for that employee. This obviously could create some situations if you are a small enough business that doing so would jeopardize your company. It's a good time to consult counsel because you're going to want to be really strategic about the way in which you either decide to go forward with providing benefits or maybe more significantly, the way you decide to deny benefits to which the employees may be entitled. The fourth potential landmine is what can be required as far as documentation from employees. I'm not going to spend very long here, but I just wanted everyone to see what you can ask an employee for. The first four bullets are the types of documentation that you can require from the employee in any situation. And in fact, you should be requiring because you're ultimately going to have to be able to document the tax credits that you're requesting. And the types of things that you'll be required to provide are the employee's name, date of leave, qualifying reason for leave, and a statement signed by the employee that they cannot work or telework due to qualifying reasons. If the employee is requesting EFMLEA leave, you can obtain some additional information, including the name of the child being or children being cared for, the name of the school or place of care or child care provider, and a statement that no other suitable person is available to care for the child. And this is significant because an employee would not be eligible for paid leave under the EFMLEA if there is a co-parent or other suitable individual who can care for the child. Now, one potential landmine, which is a call I have received relatively frequently, are employers who say, well, can I ask for a doctor's note? If they say that they're symptomatic, can we ask them to provide the same type of information that's available within the FMLA? And our advice is just to be careful about requiring the employee to provide medical information or a doctor's note. You can implicate federal or state medical privacy laws. Now, if the employee seeks paid leave under the FMLA, not the EPSLA, not the EFMLEA, but a traditional FMLA leave for his or her own serious health condition related to COVID-19, then the normal FMLA certification requirements do still apply. And in this limited circumstance, an employer may require the employee to obtain a medical certification in the same form as you previously could under the FMLA. But other than that, there is nothing in the FFCRA or CARES Act that allows an employer to require the employee to obtain a doctor's note. So just tread lightly. It's also important, there are more employees than ever that are going to be teleworking. And so there are a few things that employers can do to try to protect themselves against potential issues on the teleworking side. As we talked about, employees are only able to claim paid leave benefits if they are unable to work or telework. And the question of whether an employee is unable to telework is a highly case-specific question. It's going to depend a lot on what the employee's responsibilities are, whether they're exempt or non-exempt, what the reason they're unable to telework is, those types of things. it's more important than ever for employers to clearly document any performance issues when those employees are teleworking, to document the dates on which there were issues, to document the reasons why the employee was unable to perform, if there's scheduling issues, to document those scheduling issues. One thing we've been advising our clients is to carefully consider a formal work from home policy, and in particular, one that requires employees to perform their job responsibilities in substantially the same manner as if performing work at a physical brick and mortar work site. And the reason why we advise this is because even though there's a change in scenery, the more that an employer can objectively tether an employee's performance to what they were doing before COVID-19, the easier it's going to be to defend any sort of discipline that you have to impose in these new and novel times. And then just remember wage and hour issues, that if you have an hourly employee, there is some DOL guidance dealing with these issues, including some flexibility as to how a teleworking employee's time should be counted. And employers just need to be very vigilant about documenting when employees are actually working and paying them for the work that they're performing. Obviously, there's a situation if hourly employees are responding to emails outside of their working hours, or if they're performing work at different times than they're telling their employer that they're working. And so if you're encountering those types of issues, it's important to set expectations with employees and really document. And then finally, what we're calling leave calculation issues. If any leave is taken, or if there is a paid leave benefit that's available to an employee before April 1, 2020, that does not count towards these requirements. Both the emergency paid sick leave and the EFMLEA are brand new paid leave requirements. So it's important not to include pre-FFCRA leave when you're considering what benefits are being provided to employees. If an employee is reporting to work, leave needs to be taken in at least full day increments from an intermittent leave standpoint. If the employee is teleworking, things get a bit more hazy. The Department of Labor guidance recommends that employers work with employees and says that an agreement where both the employer and the employee agree to a form of intermittent leave in an increment of less than a day is permissible. But the only requirement as far as intermittent leave is, as I just said, that if the employee is reporting to work, to a physical work site, leave must be taken in at least full day increments. And then there can be some tricky issues that arise when other forms of paid leave come into play. And we're talking about paid time off, vacation, existing sick leave, those types of things. And a few takeaways for everyone on this call. One is for emergency paid sick leave, an employer cannot require the employee to use other forms of accrued paid leave first. The reason for this is relatively simple. The purpose of the emergency paid sick leave is to give additional leave to employees for the specific purpose of COVID-19. And as of right now, it's scheduled to sunset at the end of 2020. For EFMLEA leave, the employer may require the employee to use other forms of accrued paid leave first if it's available to care for a child, or the employee can request it. And then finally, very likely there will be complexities raised by the interplay between state and local paid sick leave requirements in the FFCRA. So if you're operating in areas where there are other obligations for paid sick leave, just be careful about that. You might want to consult counsel.
Sure, this is Ryan again. And of course, for those of us who have been working through these issues, the flip side to the paid leave obligations and entitlements under the FFCRA has been unemployment. And one of the happy developments early on in the crisis was that the DOL gave us some pretty strong clarity that for current employees, their entitlements were under the FFCRA, but for employees who were experiencing a job loss, either permanently or as the result of a furlough, their relief was under unemployment programs. And so we got some clarity that there was not going to be a situation where employees could be on furloughs and still entitled to paid leave under the FFCRA, which would have been a bit of a nightmare. Unemployment is a bit outside the scope of our presentation today, but because it has been such a large part of employment lawyers and HR professionals' lives recently, we thought we'd just have a brief note on that. A few issues that we're seeing and that we're receiving some questions around. Recall that employees who are not permanently terminated, but might be on a furlough or a temporary layoff, they're also entitled to unemployment. We've had some questions around that, and that's not something for you as an employer to be concerned about. That is really between the employee and whatever state that they happen to be in. But they are eligible for unemployment if they've experienced a job loss, even if it's temporary. Likewise, many states, including Minnesota, allow for partial unemployment benefits. In Minnesota, if an employee's hours have fallen below 32 and they're otherwise eligible based on earnings or otherwise, they are eligible for a partial unemployment benefit. And that can be useful for some employers who are in a position of having to cut hours but still want to have some benefits available for their employees. But just be aware that partial unemployment is something that your employees may be able to take advantage of. Another question that we've received a few times is around the impact of other payments. Traditionally, anytime an employer provided compensation to an employee, that would count against their eligibility for unemployment. That could be PTO payout, that could be vacation, it could be something like bonus compensation. As of now, at least in Minnesota, by executive order, the governor has eased those restrictions somewhat. So if employers want to provide a payout of PTO or vacation, for example, that's not going to count against employees' unemployment eligibility, at least for the time being. On the other hand, the executive order doesn't cover some other things. So if you are in a position where you have laid off employees, but you have also paid a bonus, something that might have been earned in 2019 and payable at the end of the first quarter or at some point before the end of the year, our best guess is that that compensation might count against employees under regular operation of unemployment rules. So just be aware that anything that you pay to employees who might otherwise be on unemployment could count against them and affect their eligibility. I won't touch on the next point very, very much because it gets to be a bit complicated, but as many of you are aware, the CARES Act unemployment benefit has really created some problems for employers in the sense that it creates a perverse incentive where unemployment may be more valuable to employees than their actual wages. And that can create some interesting and challenging dynamics from an employee relations standpoint. So be aware of that. Now I'll end this slide very briefly with a couple of points that we've repeated a number of times to employers, and so it's worth repeating here. Number one, don't advise your employees regarding their unemployment eligibility. That is an issue between them and the state, as I mentioned before. You can certainly make the point that they may be eligible and that they're able to apply, but just avoid some headaches and don't get into the realm of telling them that they will be eligible or for how much. That's not your business as an employer. You leave that between the employee and the state. Also, just be aware that we're seeing some signals now that despite the fast-moving pace and at least in Minnesota, the pretty easy means by which employees have been able to take advantage of unemployment benefits, we're going to start to see a crackdown and some real vigilance around unemployment fraud. So take these rules seriously. Employees have to experience a job loss through no fault of their own to be eligible for unemployment. And if employers and employees are playing around at the margins to try to push people into unemployment, we might be in a situation where our states are going to start really cracking down. So with that, Drew and Melissa, let me come back to you. Notwithstanding the stresses we've been all dealing with, there I think has been a national sense that we're all in this together. But maybe it's the cynical litigator in me, but I think that probably has a short shelf life. With new legislation comes new litigation. And what might employers expect to see on that front?
Yeah, this is Drew. It was Wayne Gretzky who said, good hockey players play where the puck is and great hockey players play where the puck is going to be. In the same way, I think good employers know what the issues are, and great employers are thinking about what the issues will be. And so I want to talk about three possible issues here that great employers have already started thinking about. And the first, if we go forward about one or two slides here. The first category are paid leave claims. And I've already alluded to some of this in my earlier presentation. But one category of likely claims here are going to be related to the failure to provide benefits under the FFCRA, and that's the paid leave benefits. Now, anecdotally, I have had opposing counsel who's a plaintiff's attorney tell me that their phone was ringing off the hook with these types of claims already. So I do think that the train is already in motion for employers who have failed to provide benefits. And the failure to provide benefits under the federal statute, the FFCRA, is termed to be a violation of the FLSA, the Fair Labor Standards Act. This means employers may be on the hook for unpaid benefits, possibly unpaid wages or minimum wages if they're too low. There could be civil penalties, there could be punitive damages, there could be attorney's fees. The potential risks are increased exponentially where there's the potential for a class or collective action. That is where one type of job or one type of employee is being treated wrongfully based on one act by the employer. So this really is an area that's rife for that type of litigation because you see a lot of employers either allowing benefits or denying benefits in a widespread manner. Another type of paid leave claim is the failure to notify employees of benefits. There is a notice that the Secretary of Labor has already disseminated, a model poster. It's available on the Department of Labor website. There is no specific statutory penalty for the failure to put that poster up in a conspicuous place, but you could see some claims by employees based on a failure to provide notice. And another similar risk are claims that would be based on unclear or incorrect guidance on paid leave benefits. We discussed another risk a bit earlier, but the categorization of independent contractor and employee is going to be another significant issue, and there's risk both ways, as we talked about. You want to make sure that you're entitled to the tax credit in a 100% of the paid benefits that you're paying out, but you also want to make sure that you're accurately categorizing employees too. And then as to miscalculation of paid leave entitlements, as described above, the failure to provide the full scope of benefits would be treated as a violation of the FLSA. We may also see an increase in disability claims, and I think this applies both in the present, in our current COVID-19 world, and in the future. You could see some failure to accommodate teleworking claims. So short-term, employers should carefully consider requests to work remotely or to otherwise telework, and consider whether or not the request is related to an employee's disability. And then long-term, after this is all over, you may see more employees request to work from home and contend that they or their colleagues were able to do so during COVID-19, which shows it's a reasonable form of accommodation. You may also see some of these related claims as employers begin reopening here in the near future. And then the final category that I'm going to talk about before I hand it over to Melissa are what we call compensation claims. You could see wage theft claims increase over the next few years, particularly if employers are cutting salaries, monetary benefits, bonuses, commissions, that sort of thing, or if employees are being given the wrong type of leave. For example, if they're capped at $200 rather than the higher $511 daily cap that we talked about earlier. If your employees have guaranteed salaries, you need to be particularly careful if you're looking to reduce their wages. That's another layer of complexity in litigation. And for employees who are teleworking, you could see an uptick in claims related to not being paid for the work that they're actually performing, that is off the clock work.
It would be an overstatement to say that awesome employers are anticipating that plaintiffs' employment lawyers are figuring out how to earn a living in the post-COVID-19 world. And say we could X out the word risks in here because we are already seeing these cases. So in terms of WARN Act, keep in mind there are WARN Act claims and then mini WARN Act claims based on state law actions, state law legislation, and Hooters has already been sued in a WARN Act collective action, not because of what people are wearing, which is historically what they get sued over, but for not following WARN. And the complaint allegations blast Hooters for allegedly not applying for a PPP loan and for failing to provide adequate notice. In terms of wrongful termination claims, I think there's going to be a huge uptick in retaliation based on, people feeling like employers are not complying with stay-at-home orders or what will probably be return to work orders, or are not adequately protecting their safety at work. And there's a case in Kentucky pending against Trader Joe's, which really highlights this issue already. In kind of a typical fact pattern that all employment lawyers and HR people know, an employee posted on his Facebook page that his employer was not taking steps to protect employees in accordance with the stay-at-home order. He then was out of work for a brief illness, and when he returned, his manager told him, and his manager obviously had been on the guy's Facebook site, and said if he felt that he was not being protected, he should resign. And obviously the rest is history, and the case is pending in Kentucky. Shifting over to the right side, bias claims brought by Asian American employees is sort of being tagged by the EEOC as similar to what happened post 9/11 with Muslim employees. And the EEOC is specifically tracking claims brought by Asian American employees in connection with the COVID-19 and reminding employers that when they have people return to the workplace, supervisors should specifically be told that they need to look out for particular bias claims. So the EEOC is providing guidance on what employers should do when people return and how they can head off these claims. In terms of the EEOC, keep in mind the EEOC issued a guidance saying that it was not going to issue right to sue notices. And while typically those notices are requested by the charging party, when they want to bring a suit, it is worth kind of keeping in mind that if you have a charge that's been pending for a while and you just want to get it moving, you may want to think about contacting the EEOC yourself. The beauty of what we all do is that bad behavior always finds a way to take a new form and bring new claims. And while I believe that the number of actual harassment claims is going to have to decrease if people are not in the workplace together, social distancing does limit a person's ability to grope another person. I do think there's going to be some creativity on that front. Because the world is changing so quickly, please consider signing up for a webinar on May 1st at 11 a.m. Central Time called Pandemic's Next Wave, which is going to talk about litigation that is just around the corner.
So with that, Melissa, as our participants can now see on the screen here, at some point we might return back to some semblance of normalcy, and legislators will stop talking about and legislating over COVID-19, and will perhaps revert to some issues that in Minnesota and beyond have been the focal point of a lot of legislative interest and effort over the last several years. Why don't you talk to us a little bit about what we might see in that regard in 2021 or maybe even earlier?
Thank you very much, Ryan. I'm going to kind of speed walk through what could have been, for better or worse, in Minnesota in this legislative session. I will say this, and to kind of follow up on what Molly said at the outset, Minnesota is pretty cutting edge when it comes to legislative action in favor of employees. And our legislators do not tremble when they hear words like no other state has passed anything like this. Our legislators are actually fearless and often want to be first. Because COVID-19 moved all the items that I'm going to talk about down the priority list, we cannot assume we won't see them again. And I will highlight a number of them that I think will be back next year. So in kind of the post-Me Too movement, and I say post, some people consider us still to be in it, the sexual harassment laws have really come under attack by the legislators. And I would say last year and this year, there's been a real focus on wanting to change the severe or pervasive standard as simply being too high a bar. Minnesota, the Supreme Court considered a case in November 2019. It's the case of Kenny v. Homeward Bound, in which the district court dismissed the case on summary judgment, and the district court judge specifically said in the decision that he didn't want to dismiss the case, but he felt that the severe or pervasive standard left him no choice, and he personally urged the legislature to change that standard. So no surprise, went up to the Court of Appeals. A panel of 3 female judges affirmed dismissal, and Supreme Court now has the matter, and we are expecting a decision. It is worth noting on that front that a number of other states have taken similar steps to work on changing the standard. A number of states have addressed sexual harassment laws in different ways. Some jurisdictions have extended anti-harassment protection laws to employers who are under 15, so under, what would be considered threshold to apply sexual harassment. Some states have expanded the definition of who is an employee for purposes of sexual harassment to include volunteers and contractors. Some states have limited the use of non-disclosure agreements in connection with settlement of sexual harassment claims. And the state of Oregon extended the statute of limitations for sexual harassment claims from 1 year to 5 years. So obviously plenty of nationwide activity on that front, and we will see what happens in Minnesota with the Supreme Court decision, even without legislative action. Moving on to our next slide, paid family and medical leave got some momentum in this last session, and it likely will come back. The bill would create a state-administered paid family medical leave insurance program, which would be funded through a new payroll tax on employers and employees. And employers would be required to provide all employees up to 12 weeks paid leave per year for the employee's serious health condition or pregnancy, and an additional 12 weeks paid leave for family care or bonding in the context of parental leave. It didn't make it to the Senate. Hard to predict what's going to happen, but it was out there. As it relates to a prohibition on non-competes, every couple years this prohibition on non-competes surfaces at the legislature, and historically has not gotten any momentum, and I don't think it would have gotten any momentum this year. But other states have taken that step, to get rid of non-compete, but allow non-solicits to stand. And so I think it's worth employers keeping their eye on it, but I don't see that as getting a lot of momentum. That is in contrast to the next bill, which is the prohibition on inquiring about applicant pay history. That kind of legislation has gotten a lot of momentum nationwide. A number of states have passed laws saying you cannot ask an applicant, in the context of the hiring process, what they earned at a prior employer, because to do so would perpetuate discriminatory pay practices. And so I think, if employers are thinking about non-COVID-19 issues, instituting best practices around not asking applicants about pay history is key. Moving on, I would say that the probably the most interesting of these bills, which I do think some of which we'll see again, the pregnancy leave allows Minnesota employees to obtain pregnancy leave for up to, probably it would be up to 6 weeks, but it was going to reduce the incumbency period. So at this point, they have to have been employed for 12 months, and the request by the legislature is that they drop down to a 90-day, residency requirement. Employee classification, independent contractors, just good to keep an eye on. It didn't get momentum here, but the idea is that many independent contractors would be designated as employees. And again, that has some, momentum around the states nationwide, and good to keep your eye on. So hard to predict what's going to happen next year, but I do think all of this will be moved to 2021. I don't think we'll see any action on it in 2020, and I'm knocking wood. Thanks, Ryan.
Melissa, that inspiring trip down memory lane. We can only hope that we are out of COVID and talking about more traditional issues soon. So panel members, we are almost out of time, but as we have talked about a few times, the law continues to change rapidly, and as Melissa was suggesting at the end of her last comments, we have a lot to look forward to coming out of the incredibly dynamic situation we found ourselves in. In the 3 minutes or so that we have, let me open it up to each panel member to share with our attendees here one prognostication. What do you see as one potentially big thing coming out of this environment that we've all found ourselves in? Molly, let me start with you. What do you see coming down the road?
Thanks, Ryan. I guess I'm going to keep it in the context of legislation. I see an increased tension between employers, employees, and the state as everybody goes back to a potentially different workplace. And I think there'll be some increased vigilance on employer mandate legislation, specifically wage theft, worker protections, paid family medical leave, as Melissa talked about, and worker classifications. Probably not this summer, although some of these things, if they're perceived problematic enough, could pop up in a pre-agreed special session bill, but certainly next session.
Thanks, Molly. Drew, how about you? As our resident expert on all things FFCRA, what do you see coming next?
I think it's a safe prediction that there's going to be a large volume of employment and commercial litigation over various aspects of the FFCRA and frankly, the CARES Act. A number of these lawsuits are going to involve novel issues. There won't be clear judicial precedent. There won't be clear statutory guidance. And as a lot of the people on this call know, due to the applicable statutes of limitation, that litigation risk can extend several years into the future. But I think employers would be wise to keep a close eye on litigation as it develops nationwide. That's going to inform how you want to handle some of these delayed claims as they're brought to the company. And plan now. I mean, 2020 and 2021 and maybe even 2022, prepare for an uptick in litigation. The best defense is a good offense, because I do think there's going to be a lot of litigation work when the smoke clears.
Melissa, how about you?
So to pick up on what Drew said, I think that workplace communications are really going to be under scrutiny. And I think sort of in this environment where people are, trying to be kind towards each other, the tone that employers use to communicate with employees is going to be critical. And if there isn't some empathy in the tone, I think, a jury considering an employer's communication and discipline is going to be an issue. And I think kind of on that front, employers are going to want to consider providing additional training on how to communicate to supervisors. Much more is in writing, right? Particularly where people are working remotely, and that isn't going to change probably drastically in the immediate future. And I think because more is in writing and it will be under scrutiny, a lot of care has to be given to the tone that is used to communicate. Do keep in mind as well that given the uptick that we're going to see in written communication, email communication in the workplace, the ESI costs are going to skyrocket, because when it comes to discovery, there's going to be way more to discover.
Last and certainly least, this is Ryan. I would recommend that we all keep our eyes out for future legislation. We have employees who are running out of emergency paid leave or have already. At some point in the near future, we may see even a run out of the expanded FMLA. And so as we look forward to the possibility of second waves and those sorts of things, I don't put it past Congress or state legislatures to pass further employment-focused legislation. And even if it's not COVID specific, I would say that the floodgates are now open. We have a precedent for paid family leave, paid sick leave on a grand scale. I think we can expect to see it again at the state and national level, that become an even stronger momentum for that on a more permanent basis. Everybody, with that, we are at the end of our time. We're going to take a short break now. We do want to keep on schedule, so we will be back in just a few minutes. We will start promptly at 9:30 a.m. with our next session. So thank you all. Get up and stretch your legs, and we will be back to you in just a few minutes. Thanks.